my friends! Welcome to those of you watching us for the first time. And to those of you already sharing this journey with the Academy, thank you so much for joining me again. Here, we're exploring international law. The two playlists mentioned above are the paths that we have took so far, and I am here to take it further by drawing the law alive. We are talking about subjects of international law, which you can revisit the created videos about that in my playlist above. And today, we're continuing our discussion about the third element of state, which is sovereignty. Ready your curiosity, and let's begin this new chapter together. When we talk about sovereignty, we arrive at the very soul of what it means to be a state. Sovereignty is the invisible thread that binds territory, people, and authority into one living order. But this thread is strong only when certain conditions are met. It must be effective, lawful, and legitimate. To be effective, sovereignty must rest upon real and exclusive power exercised throughout the state's entire territory. A government must be able to maintain control over its land and population without external domination. Yet, international law recognizes that sovereignty may persist even in exile, when a government, though displaced by occupation, continues to represent its state's lawful authority abroad. To be lawful, sovereignty must arise in accordance with the constitutional order of the state, not through the seizure of power by force. In the modern world, the idea of legality has become inseparable from the democratic will of the people. It is through law, not through coups, that sovereignty gains its rightful form. And to be legitimate, sovereignty must reflect the consent and representation of its people. Legitimacy gives moral and legal weight to state authority. As reflected, for example, in UN General Assembly Resolution FIT 14, 1960, on decolonization, which declares that the subjugation of peoples is contrary to the very principle of sovereign equality. These three conditions, effectiveness, legality, and legitimacy, together form the living structure of sovereignty. Without them, a state may have power but not authority, territory but not right, and rule but not recognition. Sovereignty lives where law and people meet, but its existence in the international realm often depends on a second social act, recognition. Recognition is the way other states, by their words and deeds, say to an emerging entity, "We accept you as part of this family of nations." From the 18th century onward, recognition became a central ritual of international life. A political and legal acknowledgement that allows a state to move from mere fact to functioning actor among equals. Scholars have long debated what recognition actually does. The constitutive theory holds that recognition has a creative power, an act by other states that establishes the legal personality of the newcomer. The declaratory theory, by contrast, argues that the state already exists if it meets objective conditions: population, territory, government, capacity for relations, and recognition merely announces this existing reality. In practice, both ideas live together. Sometimes recognition was treated as the legal seal of a new order. Sometimes it was simply a polite witness to something already in being. History also taught us that recognition can be political. Great powers once decided who had standing. Their endorsement opened doors and conferred practical legitimacy. Over time, however, the principle of sovereign equality and the development of international institutions have reduced the exclusive weight of power politics. Today, recognition still matters, but it is less a privilege of the powerful and more a collective matter shaped by law, practice, and multilateral institutions. Recognition can arrive at different times and in different forms. It may be express, a formal diplomatic note or treaty, or implied, shown through the establishment of diplomatic or consular relations, the signing of agreements, or admission to international organizations. Recognition may be individual, one state recognizing another, or collective, a group of states or international bodies granting membership or status. It can be given immediately, delayed, or even granted before a political entity fully meets all traditional criteria. The practice of states is often pragmatic and contextual. The legal effects of recognition are practical rather than mystical. It facilitates diplomatic relations, treaty making, and participation in international organizations. Yet recognition does not always create full rights where their underlying conditions are absent. Effective control, legality of origin, and a genuine capacity to fulfill international obligations remain crucial. States may withhold recognition when a government is born from grave illegality, for example, where force or foreign imposition has produced its authority, because international society refuses to reward palpable breaches of fundamental norms. Recognition requires no rigid ritual. It is revealed in practice. A newcomer's legal place in the international family grows from a pattern of interactions, negotiations, exchanges of envoys, mutual treaties that gradually build a web of acceptance. In short, sovereignty is both substance and stage. It must be effective, lawful, and legitimate. And recognition is the social choreography that allows a sovereign impulse to become a recognized presence in the world. In international law, recognition is not only about birth, it is also about continuity. Once a state comes into being, its existence endures beyond the lives of its rulers or the cycles of its governments. The general principle is clear. Recognition attaches to the state itself, not to the government of the day. Changes in leadership, even revolutions, do not dissolve a state's identity. The thread of sovereignty continues so long as the essential elements remain: population, territory, and an effective governing authority. This is why recognition, by nature, is often declaratory. When those three conditions are met, a state exists as a fact, and in principle, should be recognized as such. Even when governments rise from upheaval, revolutionary or insurgent, they are acknowledged only when they exercise real and stable control over the territory and population. Effectiveness remains the test of political reality. Across history, different doctrines have tried to give moral shape to this practice. The Tobar doctrine, born from the ideas of Ecuador's foreign minister Carlos Tobar, proposed that governments formed through unconstitutional means, by coup or rebellion, should not be recognized until they have restored constitutional legality. This approach was later expanded through the Bentacour doctrine, associated with Venezuela's foreign minister Romulo Bentacour, which called for the non-recognition of governments established by force. Both doctrines were attempts to protect democratic legitimacy and discourage violent seizures of power. In contrast, Mexico's foreign minister Genaro Estrada offered a different vision. The Estrada doctrine rejected the entire practice of formal recognition of governments, viewing it as an intrusive or disrespectful act toward other nations' internal affairs. According to this view, the legitimacy of a government is a domestic matter. Foreign states should simply maintain or suspend diplomatic relations based on their practical judgment, without issuing moral verdicts. Today, these doctrines remain part of the living memory of international law, reflections of how the world has wrestled with the balance between political reality and constitutional legitimacy. Together, they remind us that sovereignty endures through time, but the legitimacy of governments must always find its harmony with both law and consent. When we talk about the recognition of states, international law distinguishes between different types of recognition, mainly de jure and de facto. De jure recognition happens when a state or government is fully established, exercising effective and lawful authority over its territory and population. It is complete, final, and irreversible. Once granted, it can only end by cutting off diplomatic relations, not by withdrawing the recognition itself. However, mere participation in an international conference or treaty negotiation does not automatically amount to recognition. There must be an explicit acknowledgement of statehood or government. On the other hand, de facto recognition is more cautious. It is extended when a government's authority exists in fact, but its legitimacy or stability remains uncertain. It acknowledges the reality of power, not necessarily its lawfulness. Such recognition is temporary and revocable, allowing for limited relations like trade agreements or special diplomatic missions. If that government later consolidates its authority, de facto recognition may evolve into de jure recognition. There is also what we call recognition through judicial proceedings, when a state is brought before an international court or recognized as a party to a legal dispute. In such cases, recognition is implied by participation. The very act of being treated as a subject before the court confirms its status as a state under international law. In modern international law, we have the principle of non-recognition, a moral and legal boundary drawn to protect the integrity of lawful order. This principle emerged with the Stimson Doctrine, 1932, which declared that territorial gains achieved by aggression or force would not be recognized as lawful. It later became a cornerstone of the United Nations system, reaffirmed in General Assembly resolutions and the practice of states. Non-recognition serves as a collective refusal to legitimize illegality, whether it be a coup d'etat, an unlawful occupation, or annexation. Through it, the international community quietly speaks a powerful truth. Legitimacy cannot be born from violence, and sovereignty cannot grow from the soil of illegality. When one state fades and another rises in its place, international law faces a delicate question. Who inherits the past? This is the realm of state succession, the moment when one state takes over the rights, obligations, and responsibilities of another. It was first touched upon in the early case before the Permanent Court of International Justice about the University of Peter Pasmani, where the world saw that even sovereignty can have heirs. Succession may happen through unification, separation, replacement, dissolution, and annexation, each reshaping the map of legal identity. It revolves around two central spheres: succession in treaties and succession in property, archives, and debts. To bring order to this transformation, international law relies on three guiding instruments: the Vienna Convention on Succession of States in Respect of Treaties, 1978, the Vienna Convention on Succession of States in Respect of State Property, Archives and Debts, 1983, and the 1978 Vienna Framework on Matters Other Than Treaties, all designed to trace continuity amid change and memory within transformation. Let's begin with unification. When two or more states come together to form a single unified entity, it is like rivers merging into a wider shared current, each carrying the memory of its source. In this unification, the new state inherits much, but not all of the past. Debts of the merging states may be combined, shared proportionally, or renegotiated through agreement, ensuring fairness while maintaining stability. State property, from embassies to infrastructure, is pooled into the new entity, and archives and documents are preserved as the living memory of governance, law, and treaties. Nationality is extended to all citizens of the merging states, safeguarding their legal identity and preventing statelessness. The laws of the predecessor states may coexist temporarily or be harmonized, creating a legal mosaic that gradually forms a unified framework. Treaties may continue to bind the new state or may require reaffirmation, depending on international practice. In terms of international responsibility, the new state generally assumes the obligations of its predecessors in proportion to what it inherits, though agreements may define limits. Membership in international organizations is usually maintained, reflecting continuity. Unification is therefore a delicate balance, merging identities, obligations, and histories while creating a cohesive legal and political whole. In separation, when a state divides into multiple entities, is like a tree branching into new limbs, each independent, yet born of the same root. Debts are apportioned among the successors, often proportionally to population, territory, or negotiated agreement. State property is divided in a similar fashion, while archives are allocated to preserve historical continuity, often shared between the new entities. Nationality becomes a complex matter. Citizens are assigned to successor states based on residence or choice, with measures to prevent statelessness. Laws from the original state may persist temporarily, giving way as each successor establishes its own legal system. Treaties may continue with one successor, be shared, or be renegotiated, reflecting the principle that obligations do not vanish but are reassessed. Regarding international responsibility, each successor generally assumes obligations and liabilities connected to what it inherits. However, if a successor is recognized as a new state, it may adopt the clean slate doctrine, escaping responsibility for prior wrongful acts. Recognition plays a crucial role here. Debts and access to international institutions may hinge on whether the new entities are recognized by the world. Membership in international organizations like the UN often requires application anew for each successor state. Separation, therefore, is both a practical and symbolic exercise in distributing continuity, rights, and responsibilities. When a new state emerges through decolonization, liberation, or the replacement of an occupying regime, it steps into the world as a fresh legal personality. This is the classic clean slate scenario. The new state generally does not inherit the international debts or responsibilities of its predecessor, unless it explicitly agrees to assume them. State property within the new borders is typically transferred, while archives and documents are kept as the living memory of administration and law, guiding continuity without burdening the new sovereign. Nationality is granted to residents within the territory, but care must be taken to prevent statelessness. Treaties of the predecessor state do not automatically bind the new state, though it may choose to succeed to some if continuity is desired. Recognition by other states is crucial. It affects access to international organizations, enforcement of rights, and diplomatic relations. The new state, by virtue of the clean slate doctrine, begins without the international obligations of its predecessor. Yet, it inherits the land, population, and the potential to engage fully in the international community. Its responsibility starts anew, and its membership in bodies like the UN depends on recognition and acceptance. Dissolution occurs when a state ceases to exist, fragmenting into multiple independent entities. Debts must be divided among successors, following principles of equity, negotiated agreement, or proportional allocation. State property is similarly apportioned, while archives are carefully allocated to preserve memory and legal continuity. Nationality is redefined. Residents must acquire citizenship of successor states to avoid statelessness. Laws of the dissolved state may persist temporarily in successor territories until new legal systems take full effect. Treaties lapse unless successor states agree to uphold them, and international responsibility is distributed according to what each successor inherits. If a successor is recognized as a new state, it may invoke the clean slate doctrine and avoid liability for wrongful acts of the dissolved state. Recognition, again, is essential. It governs access to debts, property, treaties, and international organizations. Dissolution is a profound transformation. The old state vanishes, leaving behind fragments of identity, memory, and responsibility to be carried by its successors. And finally, annexation, when one state absorbs another, imposes continuity by force or agreement. Debts and treaties of the annexed state may be assumed, renegotiated, or nullified, depending on recognition and international law. State property passes to the annexing authority, while archives and documents may be preserved or controlled to establish legitimacy and continuity. Nationality changes as the population is incorporated. Citizenship may be granted automatically, or conditions may apply. Laws of the annexed state are gradually replaced or harmonized with those of the annexing state. International responsibility is generally transferred to the annexing state for acts that persist, though claims may arise if annexation is disputed. Recognition plays a critical role. Unrecognized annexations may not confer full legal rights over debts, treaties, or membership in organizations. Annexation carries both continuity and erasure, transforming the legal, social, and international landscape of the absorbed territory, while raising questions of legitimacy, consent, and historical memory. As we draw our exploration of sovereignty to a close, let us see how it flows through the lifeblood of the state. Sovereignty and territory are inseparable. The land, the skies above, and the waters surrounding it form the canvas on which a state paints its authority. Borders are not mere lines. They are the invisible threads that define where a state's power begins and ends. Sovereignty also breathes through the population. It is the state's authority over its people, the power to make and enforce laws, and the guarantee of order and belonging. Citizenship, nationality, and the bonds of the population are the living expression of this authority, a reflection of the social contract between the state and those who inhabit it. Yet sovereignty is not a solitary power. It is exercised within the framework of international law, which recognizes and limits the freedom of states to ensure peace, cooperation, and mutual respect. Even in the most independent state must honor treaties, customary norms, and the principles enshrined in the UN Charter, weaving its authority into the fabric of global order. Sovereignty also faces limitations and challenges. In today's interconnected world, shared sovereignty, supranational organizations, and international obligations remind us that authority is often exercised in dialogue and negotiation. Sovereignty is strong, but it is never absolute. It adapts, bends, and sometimes even yields without losing its essence. To see sovereignty in action, we look at practical illustrations, a new state stepping onto the world stage, asserting its authority, negotiating borders, gaining recognition, or navigating disputes. These moments reveal sovereignty not as a static concept, but as a living, breathing force that shapes the state and its place in the world. In the end, sovereignty is the invisible thread that ties together territory, population, law, and recognition. It is both the foundation and the horizon of the state's existence. And with this understanding, we are ready to turn to the next element, the government, the heart that gives life to this authority, the vessel through which sovereignty flows into action. Until next time, when we will draw the law alive and talk about that, take care of yourselves, okay?